Vinita, can we start? It's 4 now.
Yes, sir. We can start, sir. We can
Are we
start.
live? Are we live?
Yes.
Over to you, Vinita, to start.
Yes, sir. So, good evening, everyone, and good evening, Tarun and sir and my colleagues at BIREC. So, we have a great privilege to, have Mr. Tarun Khurana from Khurana and Khurana Advocates and IPR attorneys. So, today's this is the second webinar of the BIREC webinar series, which we started. And first webinar we had on the patent strategies and process. And today's session is going to be very interesting as we are going to have a webinar where we will be discussing about the patents, how they are affecting or covering the 3D printing domain. So basically how 3D printing is covered with the patents, and what are the different challenges which we are able to see when we are using the 3D printing. So without taking much time, I would request Dr. Shashindu Mukherjee, who is the Mission Director of Grand Challenges India and also heading the team of IP and Technology Management at BIREC, to give you the overview about the today's webinar and to introduce our today's speaker, Mr. Tarun Khurana. Over to you, sir. Thank you.
Thank you, Vinita. My colleagues in BIRAC, Amit as well as Sanchita and other colleagues, and Tarun. I think today, firstly, I thank Tarun for, accepting our request for delivering this talk on patents and 3D printing domain. BIRAC, as we call ourselves as an enabler in the innovation ecosystem in this country, and especially we started with the biotech domain, but now digressed into a lot of related domains as well, not only by design but by necessity as well, because biology also brings along with it medical technologies, artificial data management, artificial intelligence, 3D printings, and many host of related allied disciplines. And that's the reason biology needs to talk to engineers, to talk to technologists, to talk to clinicians, to data managers and things like that. And then the innovation, we call it a 360-degree setup of innovation builds in. And 360-degree setup innovation has all these components built to it. And when we talk about innovation, IP plays a very critical role in innovation. Because innovation, if not protected by IP, a commercial strategy or exit sometimes becomes very challenging. So to connect all these things, IP management has a critical role to play. And BIRAC, as we call ourselves, as I said in the beginning, we are enablers of the innovation ecosystem in this country. IP is one of the parts of the enabling mechanism or catalyst. And the team at BIRAC not only supports management of IP, starting from hand-holding the innovators and understanding innovations, protecting them, prosecuting them, taking them to the national phase filing, and then to help to technology management as well. We have a vertical on technology management. Sanchita manages that, and Vinita leads the IP vertical. So I think these two needs, and then those two builds in and takes the innovation to a level where it can have a strategic exit or commercial exploitation. And patent is a very critical role to catalyze it. And as I said, we are digressing into various domains. Patents and 3D printing has been a very critical role in a lot of our biological exits and management tools. And I am delighted that Tarun agreed to us to speak today and enlighten us more on what are the critical elements we should know when it comes to IP issues in 3D printing domain. And I'm thankful to Tarun for sparing his time to talk to us and enlighten us on this strategy. Before Tarun begins, I thought we'll give you a short background about Tarun. He has a very, very rich both academic as well as IP related mix, and which is one of the necessities to be a successful patent attorney. He has over 18 years of experience in broad range of intellectual property subject matters, and he is the co-founding partner in Khurana and Khurana K&K and of its patent research and IP asset firm. Tarun is among the top patent prosecution practitioners in India, and he has ranked by IAM 1000 and also by IAM 300 strategist, and basically focuses on preparation, drafting, portfolio management, IP commercial and litigation, and also valuation of IP commercialization, which is one of the and challenging areas we all face today, is valuation, how to value your IP and commercialization mandates. Tarun focuses on variety of, and that is the richness he brings in today. He focuses on electronics, telecom, computers, mechanical subject matters, and variety of areas he has been working on. And he's well versed with various global patent laws, and then which goes without saying is US, EP, Indian patent laws. And basically, Tarun is a computer science engineering person from Pune University and masters in software from BITS Pilani. He's MBA from IIM Lucknow and holds other certifications from various reputed, renowned organizations nationally as well as internationally. If I continue speaking about Tarun, I think I will be eating on his time. But without much ado, I will now request Tarun to enlighten us on patents in 3D printing. Thank you, Tarun, and over to you, Tarun. Thank you. We can't hear you, Tarun.
Tarun, can you unmute yourself?
All right, am I audible now?
Yes.
All right, perfect. Thank you so very much, Dr. Mukherjee and Dr. Vanita, for sort of having me on board, for the very kind words. And it's a pleasure always to be at the platform and contribute in whatever little way that we can as people from the industry. If my presentation can be activated, can I do it from here, or can it be activated so that I can see it as well?
I think it has to be done at your end.
Yeah, is it visible?
Yeah, you have to do it in, you have to put in full screen. Yeah.
All right. So the focus for today is on 3D printing. While I focus majorly on the patent issues and the patent aspects as far as 3D printing is concerned, I've tried to also include certain aspects of copyright as well as designs as to how they can get impacted, on what kind of registrations can be an outcome of a domain which is focused on 3D printing in totality. So I'll just touch upon them, but largely we'll focus on patents. I think most of the startups and the colleagues who are a part of this discussion today are well versed with intellectual property, and therefore I would not sort of want to take too much of time here on that aspect. But just to give a very quick flavor of it, IP is essentially any intangible property which is protected by a statute. So any idea or an invention which is technical in nature would get protected essentially by a patent. Similarly, a brand would essentially get protected by a trademark, and therefore IP becomes any intangible property which is distinct from an intangible asset in the form that it is protected by a given statute in context. Intellectual property also gives exclusive ownership to the writers, to the right owners, to for whatever creations that they've done in terms of patents or in terms of copyrights or in terms of designs. Whatever work that they've done, whatever innovation that they've done, they get an exclusive right for a defined amount of time to be able to stop third parties from, or any other third party from, actually infringing the exclusive rights which have been accorded as part of the intellectual property in context. And therefore it could essentially be a copyright in a source code of a software. It could be a logo or a brand or any other kind of graphical representation that can be protected through a trademark. It could be aesthetic appearance of any article, which could be protected through a design registration, and so on and so forth. And all of these are protected by well-defined laws, except the trade secret aspect, which is protected under the common law. All others have specific statutes or specific laws that protect the manner in which they are not only registered but enforced, litigated, as well as sought for as far as infringement are concerned. So all of that is protected, and therefore they are referred to as intellectual property. Now, patents are across the globe given for a very fixed period of time, for 20 years from the date of priority. They are given based on 3 parameters being met by all the applicants, which are novelty, inventive step, and industrial applicability. Inventive step being the most subjective and the most difficult to comprehend parameter on the basis of which the patent is to be evaluated. There are different perspectives as to of the examiner or the controller, on the other hand, may have a different perspective compared to the applicant as to whether his invention is constituting an inventive step over and above what is already there in the public art or in the prior art, versus the fact that the examiner may on the other hand feel that, you know, there is no direct document that exactly talks about the same subject matter, but here are 3 documents which in parts are talking about similar subject matter, and which when combined together will result into obviousness of the whole invention, and therefore your invention does not involve any inventive step. And that is the tussle with which patent attorneys and the examiners have to sort of satisfy to each other. And once there is a determination of inventive step, the decision as to whether to issue the patent or to dispose it off through a refusal would essentially be issued. So in essence, a patent can be for a product, it could be for a process, it could be for a product developed by a defined process, or could be for any other technical improvement that has been done in the form of a system or an architecture, which can be claimed appropriately in a manner such that it can be comprehended easily by the recipient or the reader, and that there is enough disclosure in the patent application that somebody reading it and somebody having an ordinary skill in the art is actually able to make it. So that's the level or the bar that we have to meet as far as disclosure is concerned. Patents and all, except copyrights, all intellectual properties are territorial in nature, which means that they are protected only in the country in which we file it. If we file it in India, we are only protected here, and anybody in the US can copy it, and we would not be able to touch him, and vice versa. And therefore, it's important that we strategize our intellectual property portfolio irrespective of what domain it is in, and strategize it so that we are protected in as many countries as possible, because there is a timeline associated for every single intellectual property to be registered. So it's not like we can come back after 5 years and then go ahead and file it in the US at that point in time, or go ahead and file it in other countries. There is an established route, and we have to follow that route to be able to obtain and get appropriate protection for the intellectual property at hand. Now, inventions can be given for all of these subject matters that are mentioned on the top left. They are general. What is not patented is essentially covered in Section 3K, Section 3 of the Patents Act, which essentially says that anything which is contrary to public order, anything which is claiming a plant or an animal or a part, or if you're claiming a method of treatment, or if you're claiming something which is an admixture of 3 or 4 things. Am I audible, Brita ji?
Yes, sir, very much.
All right. 1 second. Yeah, so I was basically mentioning that following are the things which are not patentable, which have been listed down in Section 3 of the Patents Act, and few of the examples have been given on the top right. Then I was going to obviously think about what would be something which would be applicable for 3D printing before we delve more into the details of 3D. I think these are aspects which are largely covered under Section 3K, which would impact the determination of whether there's the subject matter for which we are filing a patent is eligible for a patent or not, where a bulk of the patenting in the 3D space is about algorithms, which are basically firmware or software that controls the printer or the feeder or the extruder or the other hardware elements that enable the 3D printing to take place, because all the 3D printing is essentially controlled at the back end by a software. And therefore, if the innovation that we have done or the technical improvement that we have done is actually at the software end or at the algorithm end, then we will have to face an objection under section 3K and satisfy the respective controller of the patent office to substantiate that what we are claiming is not a software or an algorithm or a computer program per se. What we are claiming is a computer program which essentially enables a technical function to be done, and therefore has a technical effect and a technical character in the extent that it actually controls one or more hardware elements. There need not be a new hardware element in your claim or in the as part of the core invention, but what should be there is a clear correlation between the software or the algorithm to be able to accurately control one or more components of the underlying hardware or the apparatus that we have that would enable or facilitate the 3D printing to take place. And that is the argument that we will have to build upon. And therefore, if it's only an algorithm, we will have to clearly correlate it with the underlying apparatus that it would impact upon, and how it would make the underlying apparatus not only work, but also make it more efficient in terms of its functionality and ability to actuate or enable the printing to take place. So that correlation becomes very critical, and that's the only area that I believe in 3D printing would be of relevance from a section 3 standpoint. Now, very quickly, because this is largely information in public domain, so my focus will be on patents, but I still thought it's important and imperative that we sort of focus on printing is all about. So therefore, very quickly reading from the top left, 3D printing, or essentially alternatively also known as additive manufacturing, is a process of fabricating three-dimensional objects by layering two-dimensional cross sections sequentially on the top of another. The layering is repeated hundreds or thousands of times until the entire object has been finished through its vertical dimension. So essentially, there is a material, could be a polymer, could be a powder, could be any other appropriate material, which will be deposited across multiple iterations onto a given layer, a defined object in 3D, and that becomes the basis of 3D printing to take place. So therefore, typically there are three models which further get divided into various techniques, but these are the three major techniques for enabling 3D printing to take place, where one focuses on laser-based sintering, which we can see at the bottom of the right-hand side image, which says powder is fused onto where a polymer powder or any other appropriate layer by laser, able to make a three-dimensional object, which could be a medical device, which could really be a biomedical organ, as we would sort of learn, or could be any other three-dimensional object that we intend to essentially make with very high precision. Then there is also fused deposition modeling, which is the first one that we see, where there are melts and extrudes that are deposited or sort of passed through a particular filament, and by virtue of which there is prototyping or three-dimensional objects that are manufactured. And the third is the stereolithography, which is the SLA, where also laser as a technology is used, but the means of depositing becomes very different from how sintering is essentially done. This is the history. Won't want to take too much time here about how 3D printing has taken place, where in 1950s focus was on what kind of films, what kind of materials, and what kind of filaments can be used and derived from polymer intermediates. And then in 60s there was focus. In 70s they were focused on three-dimensional photography and reproduction. Was focused on profile development and control, so as to be able to make new three-dimensional apparatuses and systems. And therefore this technology finds its inception about 70 years back, where there was thought process of how different materials can be deposited on a given film or a layer, so as to be able to make gradually a three-dimensional object through iterative deposition of a polymer or any other film that sort of be constituting of different materials. And then I in 1984, one of the first applications which focused three-dimensional objects by through stereolithography, which we saw as one of the techniques in the past in the previous slide. This application is in public domain and can be shared, looked upon anytime. Now, 3D printing can have multiple use cases or application areas where we've sort of discussed. It could be in the biomedical space, it could be in the core biotechnology space, it could be for any other kind of additive manufacturing, where it could be a plain part, could be as simple as a chocolate-based item that could be intended to be made through a manufacturing item or through a 3D printer per se, or could be even in China, obviously people have used it for making construction equipments, as well as the whole home for that matter has been printed in parts and in a modular fashion to be able to make houses using pure three-dimensional printing based objects be created, as well as organ, as I've said, where it could be a tissue or could be an organ, could be a bioink, could be essentially any other mechanism that can be used to make any organ. This is a small snapshot of from the European Patent Office, which indicates the kind of patenting that has grown over the years in the three-dimensional printing space. This is pan Europe, which means about 4,000 applications were filed all in all in this particular space at the EPO in 2018, and therefore we can imagine that the volumes would be at least 3, 4, 5 times more as far as the US is concerned. Typical scenarios or taxonomies that form part of the 3D printing space focus on elements or components that are, for example, the extruder, the feeder, the nozzle, the print bed, and different materials, from steel to photopolymers to polycarbonates to glass filled polyamides. All of these are exemplary materials that a number of our clients have also filed patent applications in this particular space, and we'll go through it. So a variety of different options depending on the kind of use case or the application area for which we'll eventually be ending up using this printing material or for the 3D object. And we spoke about the application areas as few of the following that we see on the top left. And this is again another exemplary taxonomy where 3D materials are used, where there are solid based materials, there are liquid based, there are powder based materials. I would not want to go into details of this because this is all part in public domain essentially, but just to show a snapshot of the kind of dimensionality that is available to researchers to focus on various aspects. And as far as patenting is concerned, some patents are filed for the choice of materials, some patents are filed for the choice of materials for a particular domain. That domain could be an industry domain, could be a product level domain, could be a use level domain. So it could be in the bottling space. Within the bottling space, it could be for a specific type of industry like the medical industry, or for the beverage industry, or within the beverage industry it could also be for a particular type of material, particular bottle. So the scope is so huge that the application has to be written in a manner such that not only is what we wanted to cover encompass, but any possible design around where we feel that our boundaries should not be trespassed by a person intending to design material has to be appropriately claimed. So we can not just play with them, we can also play with, as I had mentioned, the extruder, construction of the feeder, nozzle, how they intercouple with each other, and how they can essentially be combined together to be able to, using an algorithm controlled, how can an algorithm actuate or control a particular feeder, control the movement relatively between feeder and the nozzle, any combination thereof. There is a tremendous scope on the patenting in this particular space from that perspective. Now, the above is just an example, but essentially we wanted to demonstrate even from the 3D printing space that 3D printing would democratize production, which is expected to disrupt the supply chain in totality, where we can, for example, for the algorithm or for the hardware construction of the printer, have a patent protection for the source code of the algorithm that controls or actuates that particular apparatus. We can always have a copyright protection as well. And for the final 3D product that comes out of it through the printing aspect of it, the whole that can also be given protection as far as Designs Act is concerned. So it's multiple intellectual properties cohesively being possible through a single implementation or working of an apparatus in the 3D printing space. So we the form, therefore need to be taking an appropriate call and not just protecting patents or IP in the form of just patents, but also copyrights wherever there is a possibility of the same taking place. These are just some examples where we've exemplified that in the context of copyrights for 3D printing, copyright can subsist in 3D physical objects that are to be scanned, can be 3D printed objects in terms of its artistic representation. If it's a painting that is being printed using 3D printing, then that particular painting can also be a subject matter of copyright protection. The whole software, as I've said, the CAD software program file and the source code can be regarded as an original literary work. Even if the software is an open source, if the objects are scanned without permission or the CAD file contains restrictive license duplication of object by printing it. So obviously these are issues that may come out of it, but from a copyright perspective, these are aspects that can be given protection under the Copyright Act. Even in the context of 3D printing, while this is an aspect that I've mentioned to be an issue, which we'll cover later as well, but in general, the apparatus, the computer algorithm, the construction of the whole machine, all of that is patentable subject. And same is the case with design and trademark as well. This is just another representation in the bioprinting space that we wanted to highlight here. We had done this one study, and this report is also present on our website if somebody is interested to have a look at it on iiprd.com, where we had studied about 3D printing space in the biotechnology or in the bioprinting space, where we had bifurcated that there are numerous application areas, be it on the bioprinting, the laser aspect of the 3D laser assisted bioprinting. Even in the cell type, there is 3D bioprinting material, which could be the bone cell, could be the cancer cell, could be any other fibroblast or stem cell, or could also be a fold support, any other kind of material that is mentioned on the right hand side. We've also talked about utility as to what kind of materials can 3D be used as implants, used for transplantation, used for tissue mimics or models. And all of that was studied in a heavy sense as far as this particular landscape report that we had evaluated. And then we had bifurcated all of that. That bulk of the patents are in the extrusion bioprinting space, followed by the generic 3D printer space. Within the dissection of generic tissue, 3D printed tissue or organ, we've met tissues or organs, and there are, for example, 4% on tumor tissue, and then there is focus on, from a patenting standpoint, with 6% focus on printed tissues or organs, on cardiovascular based organs for that matter. And this is the split that we had analyzed from the whole. The whole report is available on the website, and how many patents we analyzed, which all countries we had covered, all of that. Then we had also dissected what kind of cell type used, and stem cells constituted about 28% of the whole study. So we can, from these charts, understand and evaluate where bulk of the patenting is taking place, what kind of innovation is essentially being done, or what kind of cells, what kind of tissues are being used from an industrial application standpoint. Here again, this is with respect to the material, which could be, as we had discussed, could be fibrogen, could be fibrin, could be
Tarun, we are losing your
cellulose,
voice.
could be gelatin, etc. So this is the bulk of the patenting has taken place. So as we can see, for example, a sample material. Vinita, anything for me?
Actually, we are losing your voice in between. So yeah, now it's clear.
Vinita, am I audible to you?
Yes, you are audible, but we are losing in between.
Better now? Am I audible?
Yes, yes, yes.
All right. So let me know. Yeah, let me know whenever it happens the next time. Yeah. Snapshot of, all right. So this is, as I said, an exemplary of the kind of materials being used. This is again a snapshot of what kind of these or applications are these patent applications being used in, where we see that 52% of the printed bio organs essentially are focused on regenerative medicine or tissue defects. as well as followed by drug discovery or toxicity evaluation, etc. Some case studies about certain clients that we have represented in the space. This was a US application which essentially got granted to a client of ours called Prayasta 3D Inventions, which focuses essentially only on the 3D printing space very actively. And this application got allowed without any examination report or an office action, was a straight allowance that took place from the US. And I understand and recall that a corresponding Indian patent has also been granted or is in the process of being allowed for that matter. The claim for this particular application is this wise, wherein the focus is on a method of three-dimensional processes using a silicon 3D printer, wherein the method comprises of, and this is essentially three-dimensional processes using silicon 3D printer. So the claim specifically mentions about the kind of printer that we are and what is the application area in which that would essentially deploy this method to manufacture three-dimensional processes. And there are multiple steps to it, where in the first step we've mentioned obtaining a three-dimensional contour of an anatomical structure of a person, wherein the anatomical contour is a three-dimensional contour is generated. Then the second step of obtaining a first Young's modulus of elasticity specific to the anatomical structure of the person, obtaining a first weight of the anatomical structure of the person, and this essentially was all the elements that came before the characterizing portion, and thereafter we have written characterized in that. So any portion that comes before the characterizing portion is deemed to be in public domain, and the novelty of the invention follows thereafter. So the fact that there is a three-dimensional contour, the fact that we have obtained the Young's modulus of elasticity specific to that anatomical structure, and then the fact that we've obtained the first weight of the anatomical structure is all accepted or deemed to be in prior art or in public domain as accepted by the applicant. And thereafter, the invention revolves around a determination of a dimension of the designated of the designed three-dimensional processes, wherein an external contour of designed, just one second, of the designed three-dimensional processes matches the generated three-dimensional contour of the anatomical structure of the person, and the three-dimensional internal architecture is incorporated, comprising plurality of void spaces separated by a plurality of internal walls, wherein the three-dimensional internal structure is selected to match the first Young's modulus of elasticity specific to the anatomical structure of the person by. So this particular characterizing step of determining a dimension from the three-dimensional processes, wherein there is a matching that needs to be done with the first Young's modulus of elasticity specific to the anatomical structure of the person, is done essentially by these two steps. One first step, void size, a void shape, and an internal wall thickness of the plurality of void spaces, and the second step of determining a category of three-dimensional internal structure architecture based on at least one of the first weight of an anatomical structure and the first Young's modulus of the elasticity of the anatomical structure. And then the second step of dispensing homogenized biocompatible mixture layer. So the focus, as we can see, is on determining an appropriate suitable matching dimension for that particular user based on the elasticity of the anatomical structure of the body. So we first take the overall structure of the body, we then identify the Young's modulus, identify the weight of the anatomical structure, and then determine the most appropriate structure for the same. After we've identified and prepared that outline of what and how that processes device needs to be printed from a layout standpoint and from a dimensionality standpoint, then the second step of dispensing a homogenized biocompatible mixture layer by layer using a 3D printer. So the focus here is not on the structure of the 3D printer. The core heart of this invention is to identify that template or that map, I would say, or that layout basis which a reference would be set and the printer, which would be a designated printer used in this particular industry, would use that reference to be able to then use the biocompatible mixture to manufacture that processes item, to print the designated three-dimensional processes, wherein the homogenized biocompatible mixture is deposited according to the determined dimension of the designed three-dimensional processes, determining at least one void space to be filled with the filler material from the plurality of void spaces. So as we can see, the focus of this invention is on determination of this reference value that the 3D printer can use, and eventually can essentially can deposit the biocompatible mixture according to that particular usage. This is another patent application granted to I think this is a company called Divide by Zero that we had represented. Inventor was Swapnil Sansare. That's my recall. This is also a granted patent, was filed in 2016. Now this becomes a different kind of subject matter on which the patent was granted. Now, as we see, the focus of this particular claim is a system for 3D printing of an object using fusion deposition modeling, FDM, characterized in that. So here, all the steps subsequent to characterizing portion have been claimed to be novel and have been accepted to be novel by the patent office. Now this becomes more of a computer architecture level patent, where the focus is on certain control modules, or the controlling control unit or the control module of the 3D printer, where G-code file read module 102, which is configured to receive a G-code file and read the contents, and then there is a layer feature and size recognition module configured to retrieve tool path length from the G-code file. Then there is a temperature estimation and the control module configured to receive the tool path length, which came from the step above, from the layer feature recognition module, and further configure tool path default temperature of the extruder from the G-code file. So essentially these are interrelated steps. In the first step, we receive the file, the G-code file. In the second, we retrieve the tool length from the G-code file. In the third, we receive the tool path length from the recognition module 104, and the retrieve the tool path default temperature also from the G-code file. Then there is a deposition module configured to read the tool path default flow rate of a material to be extruded and a tool path length from the G-code file, and then an extruder failure repair control module configured to monitor consumption of the material in 3D printing using fusion deposition modeling, wherein the system controls any combination of flow of the material being extruded and temperature of the material being extruded based on geometry of a part of the object being produced. So as we see in the previous application, the focus was on the geometry determination or definition or establishment of what the geometry would be. Here the focus is parameters to be used for controlling the functioning or implementation of the 3D printing, and therefore this becomes a completely different kind of pattern, where 3D section 3K may have been implemented, but we were able to easily overcome, because the fact that there's a file being read and certain lengths being evaluated or extracted and temperature value being extracted is essentially being mapped and correlated to the aspect of controlling the deposition, as well as configuring the monitoring the consumption of the material in the 3D printing using. This invention is again restricted to use of FDM as a technique for enabling 3D printing of an object. Any other technique would essentially go outside the scope of this particular patent, and therefore for a person who may want to design around it, as far as this patent is concerned, may want to use some other modeling technique and enable certain aspects of similar nature, so retrieve parameters from certain values, and then based on those values monitor the consumption or control the consumption or control the functioning of the usage of the material being extruded, and also the temperature at which it is being done. So therefore these two are examples, but there are tons of patents. Now this is a flowchart of the same, where this is following the same claim, where we see reading a tool path length. Then there is the tool path length more than a predefined threshold? If yes, then we go to the left. If no, is the tool path on an infill print? Then step is of calculating the flow required, then increasing the flow to maximum using a flow control subroutine. So this is more of a software algorithm that enables controlling of the printer while the biomaterial or the material is essentially being used. However, it is clearly being correlated or mapped to the underlying hardware apparatus or the elements that form part of the machine to be able to overcome Section 3K requirements, and therefore this was held to be patentable. Now, another big company that focuses on the 3D patenting space is a company called Stratasys, which also has an Indian entity called Stratasys India. And these are some exemplary applications where this was only to demonstrate the kind of applications that have been filed for the different subject matter. In 2007, for example, they filed an application for a soluble material and process for three-dimensional modeling. So here the focus was on the process of manufacturing the material as well as the material per se. And I've given in point number 1, 2, 3, 4 below as to what the focus was. As can be seen, the first application above is a combination of making a three-dimensional object comprising a plasticizer and a base polymer. So the focus was on the material and the process of usage of that material for 3D modeling. The second application is a method for forming an object. The object comprising jetting a first material to form a plurality of layers to define a support increment, structure increment, and extruding a second material to form a layer of the object. And the third is on a consumable assembly comprising a container portion configured to retain a supply of filament, guide tube connected to the container portion, and a pump portion connected to the guide tube. So this is essentially the structure of just a very small of a component of the 3D printer, not the printer as a whole, which is the consumable assembly essentially. And the fourth is the most recent application filed in 2018, where the focus is on building a three-dimensional green compact comprising a printing station configured to print a mask pattern on a building surface where the mask pattern is formed of solidifying material, etc., etc. I don't want to go into the subject matter, and I'm happy to answer questions that might come out of it. But the focus of this patent was on the actual construction or building of the three-dimensional green compact through a generic description of there'll be a powder delivery station, there will be a printing station, there'll be a solidifying station, etc., etc. So that there are different components, a large high-level components of the 3D printer, which will get combined together to be able to manufacture specific green compact product. So this is an exemplary representation from that perspective. And now, the last portion of the space, and we can go into, I can share my screen and show other three-dimensional printing based patent applications as well, but the focus was on explaining the conceptual aspects of what kind of materials can be used, where is the patenting scope in terms of combination of materials, components of apparatus, algorithms that control the apparatus's functioning, algorithms that control how much material will come at what speed and flow rate will come, which areas would it come at, what kind of reference map or reference guide image would be required so as to be able to print this particular item, etc. All of those are areas where a lot of work has already been done and a lot of work is currently being focused as well. However, certain aspects that you have to keep in mind or should keep in mind while patenting in this space have been outlined here. First is mere change in the functional use case or an application area is not enough to overcome the test of inventive step, which essentially means that if a particular 3D printer construction plus the material plus the mechanism of printing, which is like the FDM or the other technologies, the laser-based printing, etc., that we have talked about, if they're already known for manufacturing of a particular object, merely saying that I will use the same apparatus or construction and make another object which is probably in a different industry would not be enough to overcome the test of obviousness, because the controller will say, what is the big deal? You've copied or got an inspiration of the same technology and using it in different industries. It is the same as sort of using a particular cloth. Once you know that it can be used to clean glass, then you probably take it to another type of glass and then to another type of glass and then another industrial area where it could be a fiber and not a glass. So that itself will not be enough. We will have to show that one either there is something more that we have done to the existing already known apparatus so as to make it more relevant and more efficient for that particular use case, or we will show that the use case was not earlier in a position to use the same apparatus for XYZ reasons, but due to my customizations, due to my R&D and changes in the proportions, not just of the material, but also of the design of the apparatus or in the algorithm, I was able to achieve its compatibility for that particular use case. Then it becomes a subject matter of patent eligibility and also perhaps can help you overcome the test of inventive step. But otherwise, something that is known in one industry, merely using it in another industry would not be patentable. And the same goes not just for the whole combination as a whole, but even for components. If X plus Y plus Z was known, then merely using X plus Y plus Z in another new use case would not really make it patentable in the true sense of it. Again, in the 3D printing space, because there is so much option to limit or delimit ourselves, we also have to be very careful as to what we are claiming in the application, because the longer the claim and the more words that there are in an independent claim, the narrower the claim or the worse the claim becomes. And therefore, if we, for example, like in this particular claim, have restricted ourselves to FDM, now this may be a good thing or a bad thing. But good maybe because there was no other way to actually print an object using FDM, then there is no issue. But if there are other alternatives which are easily possible and would not decrease the efficiency of the 3D printing of the object drastically, then somebody would easily be motivated to go and move away from FDM and use any other platform as well. And therefore, it's important that we not limit the scope of our patent by limiting to the material of construction or limiting to the type of printing being used or the type of modeling being done or the type of algorithm being used or the type of file being used to control the working of the different parameters, etc. To the extent possible, we should be broad, but sometimes if we go very broad, then obviously we are landing into prior arts and will become very difficult to defend the patent. And therefore, we need to find a very clear balance such that even if somebody changes a little or tries to design around, he's still within the scope of my patent, and that to that extent we have to be broad enough. And therefore, how much generic, how much specific is an aspect that you have to work closely with your patent agents to be able to very clearly demarcate as to the length of the claim and what are we right. Every word that you write in a claim, in an independent claim, only narrows the scope and would never broaden the scope of the claim. And therefore, very carefully to be chosen whether we want a specific material or we just write, like for example, biomaterial, or we say some material appropriate for that particular industry. If that be the kind of approach, then obviously we'll remain broader in that context from a scope standpoint. Third focus is also because there are multiple aspects of the whole machine. The material may be procured from one vendor. The apparatus may have different components being procured from different vendors. Then the algorithm may be ours own, because it's not like a single equipment or a component that will be manufactured just by one party. Even if you look at this kind of a claim, the aspect of a claim of this nature, for example, the material being used for processes may be procured from somebody else, and the 3D printer, which is an offhand printer, may be procured from somebody else. And then our algorithm may be our internal algorithm, but some component of it in terms of the biocompatible mixture of the material may be from somebody else. Now here in that particular case, if a party is actually printing using undertaking 3D printing for such processes, and they are procuring materials and components from different parties, they may then in that particular case say that, okay, your claim requires a particular type of homogenized biocompatible mixture layer. I am not using that kind of material. I have not manufactured it. I am procuring it from somebody else. So you go and sue him. I am not the one. And then I'll have to basically go and argue that heart of my invention is essentially in the algorithm per se, as to how this particular object is created. The reference image is created based on which the printing is. So if the reference image is being created by you, irrespective of where you are buying the 3D printer from, or procuring the material from, all of that becomes irrespective. And therefore you will have to argue, but we have to bear in mind that in the 3D printing space, there'll be multiple aspects from multiple particular companies, and therefore it will become difficult for a patentee to prove infringement by a single party. And therefore a claim should be written in a manner such that it can be targeted towards only one party and not requiring other parties to be a part of it. So if it's algorithm, then let's focus just on the algorithm and not on the step of depositing, because the step of depositing will not be done by the party who did the algorithm development. It will essentially be done by somebody else who may be actually doing the printing action. And therefore that becomes the third challenge. The last challenge is, again, as I had mentioned earlier, is on section 3K, where they pertain to computer program or algorithms involved in controlling 3D printing. Here as well, unless we correlate as to how our algorithm controls certain one or more physical tangible components and enables technical character to be brought in, or a technical effect of 3D printing to take place, it will become difficult for us to obtain a patent. And therefore that correlation becomes very difficult, very important, and necessarily would require us to draft the application so that that correlation is demonstrated, and we can map that owing to my algorithm, I'm either making the printing action more efficient, or I'm reducing the usage of the material, or there is some efficiency being created which was not there in the prior art earlier. And therefore that reasoning would have to be given accordingly. So with this, I think this is my preliminary aspect, where I wanted to focus on what the 3D printing aspects are, what are the components of 3D printing, what kind of claims can we write, what kind of language are we to write, what kind of challenges we would essentially be facing. And I'm happy to answer any question, not only on 3D printing, but even on patents in general, if the colleagues here have. Vanita ji, I'm happy to sort of take it forward on the question answer session.
Thank you, Tarun, for giving us the wonderful insights on how patent is affecting or patent controls the 3D printing domain. So now we have some time left for the question and answer. So I can see yes, one question is there by Sheetal Kumar. Any other participants who wants to ask the question, maybe they can directly ask to the speaker and the expert, and or otherwise you can write your question in the question box, which option is there. So either way you can post your question. So Tarun, we have one question by Sheetal Kumar, which is basically on what he is trying to ask, like while pursuing the application of 3D printing, specifically he is referring to pharma application. So each application demands some application specific modification in machine. So this is the question, like whether for each application you have to modify the machine for each application of 3D printing.
No, at a technical level, we may require to, obviously, because the reference image would change, the flow rate would change, the control parameters would change, and therefore it is very likely that for depending on the kind of industrial application we have, not only the machine but also the control module would have to essentially undergo a change in that sense. However, from a pure play patenting standpoint, we will have to first identify if there is something novel or new that has been done. Then at what stage is it? Is it at the machine level? Is it at the software side? Is it at the material side? And therefore, if, for example, if it is at the material side, then obviously we'll have to correlate that material with the pharmaceutical sector. If it is at the software end, then perhaps maybe the application being in the pharma space doesn't even matter. Then we can just talk about the application and how it would control the printer in totality. If it is pertaining to a dispensing mechanism, if the novelty lies in the dispensing mechanism of the excipient, for example, in that space also, then the pharmaceutical aspect may not really need to narrow the scope of the claim. So we'll basically have to evaluate where the inventive step lies, and if that inventive step requires us to limit the scope to that particular industrial area or application area, only then is when we should do it. Otherwise, it may not even be required.
Yeah. So Sheetal Kumar is actually, he is referring like how much broader coverage, as a startup they need to think about while maybe I assume that he is asking for the patent application, like how to address the broader coverage aspects while writing a patent specification, considering they are the startup company.
And
And
that
they are
would be a
focused,
very
if they are focusing on multiple applications, or because his previous question was on the application specific 3D printing. So I think he's trying to ask like how we can cover as a broadly we can cover this.
I think that answer will depend on the kind of space that they're in. It's very hard to say broad versus narrow unless you get into the specifics of the application. I don't think that the intention should be to broaden it to such an extent that the patent doesn't even get granted. So it may even be better to sometimes have a strategy of filing multiple applications at different level of broadness. As a startup, because under the DIPP scheme, they don't even have to pay any attorney fees, and they only have to pay the government fees of 1,600 rupees. They can easily afford to file multiple applications, 3-4 applications. One of them could be very narrow, one of them could be broad. All of them can be filed together on the same day, and therefore none of them would hurt each other, will not act as a prior art or a prior claiming subject matter for each other. And therefore I would always suggest filing multiple applications at different levels of narrowness and prosecute all of them. Maybe the broadest one also goes through, maybe the narrowest one becomes the easier one to allow, but perhaps that could be one strategy. The other could be to deliberate with your patent attorney, sit across the table and tell him as to what the invention is all about, and then the scope can be defined as to what level of narrowness. But otherwise, unless you understand the subject matter, it's very difficult to say at what level of broadness should we be at.
Yeah, I mean, because you have covered three aspects in your presentation. One is for the algorithm, other is material, and one is for the printer itself. So depending like what kind of innovation any startup has come up, then the broader aspects or the narrower aspects may be covered while writing the patent specification. So
Absolutely.
yeah, so I don't see any other question, but I do have one question, Tarun, if I can ask you. It's
Yeah,
which
please.
looks to so it's a very for me out of curiosity I'm asking for this question. So basically you did mention about the algorithm, like if someone has come up with algorithm and we can think about using it with the help of the 3D printer. So say for example, if I am sourcing the 3D printer from someone else and material from some other vendor, and the novelty or the inventive component is in my algorithm. So when we try to put the algorithm as a part of the patent specification, we always say there should be a some hardware component to be integrated so that we can take the software and hardware as a part of the patent specification. So in this 3D component or 3D printing domain, where we see the how algorithm or the software part can be taken for the part of can be taken as a part of the patent specification.
That you have would have to be described and claimed in a manner such that it is portrayed to be controlling the 3D printer. You may be procuring the printer from a third party, but and the functioning of the printer does not vary that significantly, because you would know what kind of printer, what kind of deposition, what kind of modules or components would form part of the printer. And therefore, the manner in which your algorithm would send instructions to or control one or more components of the printer would as to have to be explained, and that explanation would indicate the correlation to how the software would control the underlying hardware. There need not first of all be any there need not be any new hardware in your 3D printer per se, and the software would, for example, there has to be a control module, then there may be a encoding module, then there may be a decoding module, there may be a temperature control module. So the temperature control module would control certain elements or components of the 3D printer right at the end of the day. So that component would have to be mapped to say that, okay, a temperature control module configured to retrieve heat values from one or more components, whatever. You have to define those components, and then as a result of it, control the flow rate of the biocompostable material into the whatever the container in which the material would essentially go. So control the flow rate in a manner such that the heat variable ratio decreases below a threshold value. Once you write a claim of that nature, where you are trying to correlate that, okay, from here is how I got the temperature values, and from here, by virtue of that, I am controlling the flow rate from a source to a destination of a 3D printing material, so as to be able to reduce at a relative scale the temperature values so below a threshold value. Now that clearly has correlated your algorithm of the temperature control module or unit in a manner such that what you have claimed is essentially an algorithm, but it is essentially controlling the flow, the temperature, or various other aspects that might be varied as part of the whole control architecture of the algorithm.
Yeah, got the answer. So another thing, Tarun, because you are actively involved in filing the patent specification for the startup community. So what is the how do you see this trend by the startups in this particular domain? Like is it like increasing, or we don't have much patent in this area? So what is the current?
I think the majority, there are very few big companies in India in this particular space, and it's more majorly the US entities which have bigger and wider portfolios. Indian entities, I don't see any big entity that is filing, say, more than 10 applications a year. And any company that does not file more than 7 to 10 applications cannot be considered to be a sizable entity in that sense. There may be a lot of entities that may be commercially doing a lot of work in the 3D printing space, but not on the IP front as much that we notice in the 3D printing space. And therefore, I personally feel there's a lot of scope in the area, because the industrial applications are so huge, and there is very little work done on the IP front in the 3D printing space compared to artificial intelligence or any other domain where there is a lot of maturity that has come into the ecosystem on the IP front. And therefore, I particularly feel that the startups aren't really focusing much on the patent of the IP space as we see it. One application, 2, 3, 4 a year, and that too not consistently, may not be enough for us to say that there is enough maturity. So I think a lot of scope, a lot of potential, and surely the numbers can scale up.
Yeah. So so Tarun, I don't see any other question from the participants. So maybe if I can request my colleague Amit, in case he has any question to you. Amit, do you have any question?
I have one question. So thank you, Mr. Tarun, for a wonderful session. I just wanted to know more about this distributed infringement. So how our grantees can avoid this thing, because as you rightly said, there are multiple technologies, platform technologies, which is already known, and you have shown in your slide that this is the basic concepts, and most of the innovators are using the same kind of platform technology to come up with, to finalize their products. So I just wanted to know some more about that, how they can avoid this distributed infringement part.
So distributed infringement, I think the one and the major way that we try to write our claims will always be to write it from a perspective of one device. So whenever, for example, even in the software space, if there is a user authentication taking place, and the user authentication will always include at least 2 elements, right? There will be a server which will authenticate the user, like the Google server, and there'll be a client device on which the user will enter his username and password. I'm just taking a simple example. So to avoid distributed infringement, always choose one side. Would you rather sue the customer or the user, or would you rather sue Google? And if your focus is on suing the bigger entity or the major entity or the entity that would essentially have the major pure play, and it will become very difficult for you to enforce it against the customers. So your claim has to be written from the perspective of the server, which is, for example, the first step would have to be receiving comma, from a user computing device, comma, first identifier and a password or an authentication password associated to the first, and then authenticating it from a database in the server, whether the password and username is matching, sending a confirmation to the user, comma, wherein the user based on said confirmation is able to successfully log into the system. I'm just taking a very simple example here. All the three steps of receiving, authenticating, and transmitting are done by the server, and therefore they will never be distributed infringement, because if somebody does a similar authentication, it will always be the server end or the company that is hosting that server that you can go and attack. So even here, for example, even in the 3D printing space, for example, if your focus is on the machine, then you focus on the machine. Then you don't say that, okay, putting from the user or essentially inputting from the software certain inputs to control that machine, because then there are two components. Then a few steps are being done by the software and a few things are being done by the machine, which could essentially be two different entities all put together doing it. Machine could be from ABC company, it may be deployed at XYZ company, and that company might be doing the software angle of it. So always put it from the machine perspective. Say, okay, receiving this biomaterial, depositing this biomaterial, enabling the printing to take place, receiving instructions from the software to enable certain things to be done, receiving instructions to control the deposition or the flow rate, receiving. So there, all the steps are being done by the machine, and as a result of which they will never be distributed infringement. So you choose your sides and write the claim from the perspective of just one side, so that all the steps of the method claim or modules of the system claim are all present in one device.
Thanks.
Am I clear?
Yeah. Thank you so much. So I also have one another question. So as you said, this 3D printing trend is increasing in Europe. And what about the India? Have you seen the similar kind of increase in our country also?
So as I was mentioning to Dr. Jindal as well, we don't see many patents being filed in Indian context. We did run some searches earlier in the morning today as well, but very few patents, I would say. Hard to give numbers, because Indian Patent Office is not very easy to do searches on to get numbers. But very few patents, 1 or 2, 3, 4 companies filing a couple of patents here and there. So I would only say from that perspective. Otherwise, it's more companies like Stratasys, which are filing more actively. Stratasys would have numerous patents in the US and Europe, and also has a decent portfolio in India and is trying to grow as well. So I think it's more foreign companies trying to file patents in India compared to Indian companies dominating. Like there is a domination, for example, quite heavily in the UAV space. Some companies are very heavy. Companies like Geo is very heavy in 5G, 6G space, but very little focus in terms of volumes by Indian companies.
Okay, fine. Thank you so much for your answer. Thank you.
So if I can request Dr. Sanchita, do you have any question?
Just curious. I was just curious to know that what would be the percentage of organ or biology related 3D application areas in 3D printing patents. In India, I presume that it is minuscule, the total number, but globally, if we see in US and EP.
I mean, it's hard to give a number, but I can share with you this study, because this study was particularly focused that we had done from IIPRD on bioprinting space. So I think if you download this study from IIPRD's website, it will give you the exact number of patents that we had overall analyzed at a global level or at the US level. But I think bioprinting space essentially would not be more than 30% or 25% of the total 3D printing space.
25 to 30% would also be a good number, I think, if the applications are actually leading to products.
Yeah.
It may be, ma'am. It may be, but yeah. I don't, surely not more than that, could be surely lesser. But again, the volume can be more comfortably indicated in that report. I don't have a copy of it right now, but it's on the website for sure.
No issues. I'll have a look. Thanks. Just out of curiosity. Thank you. No more questions, Dr.
Right,
Meena.
ma'am.
Thank you. So thank you, Tarun. Tarun, I mean, I don't see any other question from the participants. So thank you so much for taking out time and apprising all the participants, including us, about the how the patent is becoming a challenging part for the 3D bioprinting domain. So
Right,
it
ma'am.
is always good to hear. So thank you so much. Thank you so much.
Pleasure, ma'am. Thank you so very much, and thank you everybody for the time. Thank you.
Thank you, Tarun.
Thank
Thank
you,
you very
everyone.
much. Thank you, Tarun. Thank you, everybody. Thank you.
See you, sir.